Today I will introduce you to the Tailte Éireann State Property Unit for first registration. I will provide an overview of the Tailte Éireann Validation Unit and Tailte Éireann's query management process, and I will then be giving some practical guidance on how to prepare an application for first registration using the prescribed Form 1 for freehold documentary title and the prescribed Form 2 for leasehold documentary title. I will also provide some guidance around first registration applications based on possession under Forms 5 and 6. As I go through the webinar, I will show you how to navigate to some relevant areas on our website. The State Property Unit for first registration was established in our Roscommon office in 2022. A dedicated team of legal, mapping and administrative staff process first registration applications lodged by state and religious bodies under Forms 1, 2, 5 and 6. We have a single point of contact via info.spufirstreg@tailte.ie. We know that many state and religious bodies have legacy matters requiring first registration, and the Centralised State Property Unit for first registration seeks to encourage lodgement of all new and legacy applications so that we can extend the land register and state and religious bodies can update and better manage their asset registers. In 2024, Tailte Éireann created a validation unit whose role is to review all applications against a checklist on lodgement. The checks are clerical in nature. Where an officer identifies an error with the documents and/or fees lodged, then the review stops and the application is rejected. The practitioner must relodge the application using the relodge facility on Land Direct to ensure that fees are carried into the new application. There are checklists and guides available on our website which you should become familiar with, as they contain the relevant matters to be dealt with before lodging your application. If you engage with the checklists and guides and ensure your documentation is carefully proofread before lodgement, then you should be able to avoid rejection at validation stage. And also importantly, reduce the number of rulings a deciding officer may need to raise once they examine the application. I will show you how to navigate to a checklist and guide now. When you land on the home page, you can click on Resources, then Checklists and Guides. From here you can navigate to the Form 1 and 2 checklist and guide. There are also checklists and guides for Forms 5 and 6 and for registered lands and Form 3 applications. The checklists and guides direct you to the relodge process, which, as I have mentioned, is very important to follow to ensure your fees are carried across to the relodged application. The guide also provides information on the Form 17, which is an important part of any application and needs to be completed accurately. The checklists and guides have various helpful links embedded within them, which will bring you to, for example, the fees order or to the prescribed Form 1. I recommend you have the relevant checklist and guide open as you prepare your application. Once an application is validated, it comes across to the Legal Services Unit for substantive examination by a deciding officer. At that stage, it can be rejected, queried or completed. Having come through validation, the likelihood it will be rejected is minimised. Many applications can go directly for mapping and completion, but if there are still outstanding issues preventing registration, then we will raise rulings. Rulings will be raised via email, with 1 month given to respond in full. Please respond via email where possible by replying directly to the email you receive. This will ensure the reply reaches the relevant deciding officer in a timely manner. When your response requires lodgement of, for example, deeds or compliant maps or certified copy documents, then please send them by hard copy to the appropriate office. On the expiry of the month, a further 10-day letter will issue to you, warning that the application will be abandoned if your full reply is not received within that time. We cannot accept piecemeal replies or requests to extend time. If your application is abandoned, or if you choose to withdraw the application, then you do not lose priority. Date of registration for first registration applications is the date of completion by settling of the folio. Rule 51 refers in that regard. This is different from registered land applications, where the date of registration is the date the application is received for registration, Rule 60. That is the date of lodgement. So be aware of that important distinction. Rules 15 and 16 of the Land Registration Rules set out the documents required for a Form 1 or a Form 2 application, respectively. However, consideration should first be given as to whether a Form 3 solicitor certified application can be made. I do not cover the Form 3 procedure in this presentation. However, there is a practice direction on our website which, along with the relevant Rule 19.4, will provide you with the relevant guidance you need. The Form 3 procedure attracts lower fees and has a quicker turnaround time for applicants. On a first registration application, you should ask yourself the following questions as you compile the required documentation. Title. What title is being applied for? Applicant. Who is being registered? Property. Is identity proven? Burdens. What burdens are registerable? In relation to the title, the usual title applied for under a Form 1 is for absolute title. In Form 2 applications, you can apply for absolute leasehold title or more commonly good leasehold title. If you apply for absolute leasehold title under a Form 2 application, then you must provide evidence of the freehold title and any intermediate leasehold title, which can prove difficult. So please ensure that you only apply for the title that you need to register for the subject property and that you are in a position to prove. Always go to the prescribed forms, which can be accessed through our website, as you can see on this slide, rather than reusing a form that you may have saved previously, as that previously used form may result in errors being carried through to the new application. Ensure as you go through and complete the form that you only make the required and allowable deletions and/or modifications. Other than that, you must adhere strictly to the relevant prescribed form. The notes to the prescribed form are a useful aid memoir and should be consulted on each occasion. If you don't know where to access the form you need to complete for your application, please go to the Forms tab on our website and you will find all of our prescribed forms. The prescribed form must be sworn by the appropriate person. The form cannot be declared. You must amend paragraph 1 to reflect the capacity of the person swearing the affidavit. For state bodies, law agents, property managers, directors of service, assistant principal officer grades and above, for example, are all acceptable as deponents once they aver that they are duly authorised and possess the necessary means of knowledge to swear the affidavit. We need to be satisfied as to the identity of the application property. The application map and the description of the property in the Form 1 or Form 2 should always match. Where the property has been identified by reference to a map attached to a deed prior to the route of title identified in the statement of title, then please lodge that deed to evidence the identity and boundaries on title for the application property. Identity is often an issue for state bodies, as deeds may be very old and without maps or missing. There are several ways that we can overcome this. We may request a declaration of identity from an architect or engineer, or a Tailte Éireann valuation office map, which can assist with identity. We may request details of adjoining owners for service of notices, or we can direct a site or newspaper notice. So consider what evidence you have on identity as you prepare your application and provide supporting information with your application to avoid the requirement for rulings on the point. Part 2 of the schedule to the Form 1 or Form 2 should only contain burdens registerable under Section 69 of the Registration of Title Act 1964. The most common of these are fee farm grants, charges, covenants and conditions, and leases where the term granted is 21 years or more. Do not insert Section 72 burdens, such as short-term leases or rights of way created prior to first registration, as they are not registered on a first registration application. They affect without registration. Title to be shown should be a period of at least 15 years commencing with a good root of title. We require a concise statement of title, giving in chronological order a summary of the documents and the events and facts on which the applicant's claim to the property is based, commencing with a good root of title. It should specifically identify the root of title. Please remember that if the title commences with an assignment of the leasehold interest or a conveyance of a fee farm grant, the lease or the fee farm grant should be recited and lodged and trace that title to the applicant. Pre-root documents should not be listed in the statement of title if the title is based on a good root. However, if the root of title itself recites a deed that creates a Section 69 of the Registration of Title Act 1964 burden that continues to affect the title, or an indemnity regarding a fee farm rent, or there is a pre-root deed that proves identity, then that pre-root deed should also be lodged. A list of documents is not sufficient. You need to set out each deed and state its effect on the title. This slide sets out a sample statement of title. The names in the slides are fictitious. Once you have a good root of title of at least 15 years vintage, use that as your root of title. In this instance, the 2000 deed is identified as the good root of title. If you need a deed prior to the root deed to deal with identity, then lodge that deed and confirm that this is the reason it is being lodged. In this case, the 1995 deed is a pre-root deed and is lodged to prove identity only. The statement of title in a Form 2 application will always start with the lease. You should then skip to the most recent assignment for value, 15 years or older, that would constitute a good root of title. In this example, the title lease dates back to 1850. However, the applicant can then skip to a deed of assignment dated 20th of December 2000 and trace title from the purchaser in that deed of assignment up to and including the applicants. Please do not include intermediate title in the statement of title. You will notice that the charge on the last slide dated 20th of December 2000 was in favour of AIB, whereas the deed of release was executed by Pepper Finance. Where this occurs, you need to provide supporting documents to show how the entity releasing is empowered to do so. For example, global deed of transfer of the loan. This slide provides further information around our requirements for releases. You should therefore ensure that relevant supporting documents for such releases are handed over to you on the closing of the sale or form part of any undertaking provided to you on closing, as we will request them on rulings if not lodged with the application. Lost deeds often cause difficulties for state bodies, given the historical nature of deeds as well as the completeness of records held. Where you are preparing an application and a deed or deeds are lost, then be aware that we require a lost deeds affidavit, along with secondary evidence of the deed by way of a memorial if it was registered in the Registry of Deeds, or a certified copy of the deed. The affidavit should cover the points set out in the slide, including an undertaking and indemnity in favour of Tailte Éireann and the state for any loss that may occur if registration proceeds based on the deeds lodged. the applicant should swear the affidavit as their title is being guaranteed by the state. I am going to briefly discuss first registration applications based on possession. These applications can arise where the applicant has been in long or adverse possession, or where the applicant has no title documents in their possession. It is important to identify whether the property is currently unregistered, which would require a prescribed Form 5 to be completed, or whether it is in fact already registered land, in which case the Form 6 is the correct prescribed form to use. Again, please have the relevant checklist and guide open as you prepare the application to ensure that you include all the required documents, thus keeping rulings to a minimum. State bodies regularly have a significant history of possession, often upwards of 50 years. However, unless the property comprises foreshore or state property, once the applicant can demonstrate a continuous period of 30 years possession, then please set out the history of possession from that date rather than tracing back 50 or 100 years. Set out the history of possession in a clear manner as concisely as possible. Lodge the supporting documents that are referred to in the affidavit, such as death certificates, grants of probate, diocesan records, utility bills, etc. Don't wait for us to issue rulings seeking this information, but rather lodge it up front so we can progress the application in a timely manner. This slide sets out the statutory limitation periods for adverse possession, and sometimes applicants do not realise the distinct and quite different limitation periods depending on the type of property involved. This slide sets out the minimum documents that must be lodged on a possession application. Note the difference in fees between a Form 5 and a Form 6 application. Always ensure that you fill out the Form 17 correctly identifying the application type so that the correct fees are generated. A map is always required on a Form 5 application, but may not be required on a Form 6 application if all of a folio or all of a plan of a folio is involved, so bear that in mind. Most importantly, please remember that a capital acquisitions tax clearance certificate, being a Form CA12 or a Form IT76, must be lodged with the application, and the application will be rejected at validation stage if it is not enclosed. I want to highlight a common issue that arises with state property applications, and that is the devolution of title. Property historically vested in an entity which no longer exists, or where functions transferred, and we need to see how that title to the property devolved to the applicant. Always deal with this upfront within the application to avoid the need for a ruling to issue on the matter. I show the example on this slide where title devolved from a hospital management committee down to the HSE, or from a town council down to a county council. Please lodge the relevant legislation sections showing that devolution, again to avoid rulings being required. In conclusion, always keep matters as simple as possible. For Forms 1 and 2, use the latest deed available that constitutes a good route so that you can keep the statement of title concise. Lodge your capital acquisitions tax clearance certificate with all Form 5 and Form 6 applications, and in all cases ensure identity is proven, and set out any registrable burdens properly. Engage with the validation checklists and guides and mapping guidelines before you lodge the application to ensure that you have dealt with all of our requirements, and remember the importance of filling out the Form 17 accurately. We want to be able to send on applications for mapping once they have passed validation and from there to completion. Finally, please consult our practice directions, legal office notices, land registry rules and resources, which are all set out on our website tailte.ie when preparing any application. I hope that this presentation will assist you when preparing future first registration applications, We encourage state and religious bodies to lodge their first registration applications to us here in Roscommon and look forward to engaging with you.